In 2006, a group of neighbors outside of a town called Parker, Colorado, got together to oppose an effort to annex their neighborhood into the town. They had moved there specifically to get outside of the town. So they did what Americans have been doing for literally 200 years. They walked the neighborhood, they spoke to neighbors, they sent out postcards, they put no annexation signs in their lawn. And because of those efforts, they were sued by the chief proponent of annexation under Colorado's campaign finance disclosure laws, because they had the temerity to speak out without first registering with the state and disclosing all of their activities. Today's decision held that the First Amendment prevents the state of Colorado from requiring small grassroots groups to register and report all of their activities simply to be able to speak out for and against ballot issues. The Institute for Justice has been arguing for years now that the states and the government do not have a legitimate interest in requiring individuals or groups who simply want to speak out for or against ballot issues to disclose all of their activities. Now a federal court in the 10th Circuit has agreed with that. The court basically held that the state does not have a legitimate interest in forcing individuals or groups to disclose all of their activities simply to speak out for or against a ballot issue, which after all, unlike a candidate, cannot be corrupted. Campaign finance laws impose enormous burdens on both the right to free speech and the right to associate. Simply to speak out about a ballot issue, our clients had to register with the state as a group called an issue committee. They had to appoint a treasurer, open a separate bank account, and file a number of disclosure reports disclosing even as little as every $20 contribution and expenditure that they made, simply to speak out and exercise their fundamental First Amendment rights. The bottom line is this: disclosure laws and other campaign finance laws impose serious costs on free speech. The 10th Circuit has now correctly recognized that and held that the state has no legitimate reason for imposing those costs on individuals who simply want to speak out.